Hello and welcome to the Readout's Regulatory Roundup, where we will be discussing matters affecting the health and social care sector, discuss how this can impact you as a provider, and offer you insights into how you can minimise risks to your business. I'm Caroline Barker, a Director and Non-Practicing Solicitor at Readouts. Today, I am joined by my colleague, Nicola Wheater. Nicola is one of our solicitors and has a strong regulatory and professional disciplinary background. Today, Nicola is going to be talking about the fitness to practice and whether and when a practitioner's ability to carry out the role is called into question by their regulator. Now, this could be a GP, a nurse, or a social worker, for example. This can not only be a problem for the individuals themselves, but also for providers carrying on regulated activities, either because the registrant is both registered as an individual practitioner with their regulator, for example, a doctor with the General Medical Council, but also as a registered provider with the Care Quality Commission, so again, a GP practice. But also if a provider is employing a practitioner, for example, a nurse who's questioned by the NMC. So these sorts of proceedings can really have an impact on multiple aspects of a business. So really, it's probably best, Nicola, if we start by going back to basics. And can you explain what does fitness to practice actually mean?
Sure. So fitness to practice essentially means that a practitioner has the requisite skill, qualification, knowledge, experience, health, and good character to complete their job safely and effectively. Students on an accredited course who have completed their studies will then go on to register with the regulator, and the regulator will only grant them registration status if they deem them as fit to practice. In connection with practitioners already on the register, they will need to declare on registration renewal that they remain fit to practice.
Okay, excellent. What sort of actions may call a practitioner's fitness to practice into concern with their regulators?
The best way to answer this is with reference to the fitness to practice impairment grounds. These are also known as statutory impairment grounds in regards to statutory regulators. However, voluntary accredited registers also have these grounds. Generally speaking, there are 6 grounds, and they are performance or competence concerns, health, convictions or cautions, decisions of another regulator or body, insufficient knowledge of English, and misconduct. Whilst most of these are pretty much self-explanatory, misconduct generally means conduct which is considered deplorable by fellow practitioners or falling short of the standards required. Examples of misconduct cases could be plagiarism, inappropriate social media content, or inappropriate sexualized activity with a patient or a colleague. In regards to decisions of another regulator or body, this mainly affects practitioners which are dual regulated, i.e. they're registered with 2 statutory regulators or non-statutory regulators, and one of these could be the Care Quality Commission.
Okay, so quite a range of ways in which their fitness could be called into question. So how would a practitioner know if that's the case, that a regulator is calling into question their fitness to practice?
So a regulator will always formally write to a practitioner and notify them that they are subject to a fitness to practice investigation. This is normally called a notice of investigation, and it will be sent to the practitioner's registered address and email address, which is why it's really important for practitioners to keep their details up to date with the regulator. This may also be accompanied by a referral to an interim orders panel hearing at the same time.
Okay, so you've mentioned an interim order there. Can you explain to people what an interim order is?
Sure. An interim order is an order imposed in the interim by a fitness to practice committee whilst the regulator continues their substantive investigation of the concerns raised against the practitioner. Usually an interim orders committee or interim orders panel will hear interim orders referrals, and they are able to impose an interim order of suspension or conditions for a period of maximum of 18 months. The test that the interim orders panel or committee will apply is whether it is necessary for the protection of the public, in the public interest, or in the registrant's own interest for an interim order to be imposed.
Okay, so you mentioned an interim order, which obviously suggests it's an interim measure. That presumably is part of an overall fitness to practice investigation. So that would be one of the stages. What are the main stages in a fitness to practice investigation generally?
Sure, there are mainly 3 investigation stages. The first one being from initial investigation to case examiners, stage 2 being the case examiner stage, and stage 3 being case examiners to a hearing if it's referred. I just want to break those down into a bit more information. So the first stage from initial investigation to case examiner stage is when the regulator will investigate the concerns raised against a practitioner. This will usually mean interviewing witnesses or collating any documentary evidence to prove the allegations. Once the regulator has completed their investigation, they will then disclose all of their documents they intend to rely on to the practitioner, along with the allegations that they've drafted reflecting the evidence. The practitioner will then usually have 28 days to provide a written response to the regulator, and all of these documents will then be passed on to the case examiners. We're then at stage 2 of the process, which is the case examiners stage. The case examiners will then review all the evidence and determine how to dispose of the case. The options available to the case examiners are to close the case with no further action, adjourn for further information, impose a warning or provide informal advice to the practitioner, refer to a fitness to practice hearing, or refer to another process, which is generally called consensual disposal or agreed panel disposal if the regulator has this. The test that the case examiners will apply is the realistic prospect test. This basically means that the case examiners determine on the evidence before them whether there's a realistic prospect of the allegations being found proven at a fitness to practice hearing and the practitioner's fitness to practice being found impaired. If the case examiners determine that there is a realistic prospect, then the matter will be referred to a fitness to practice hearing. If it does, then we'll fall into stage 3, whereby the regulator and the practitioner will both begin to prepare their case or finalise or fine-tune their case for a hearing. And this will then follow in regards to disclosure, preparation of bundles, and having the hearing itself where the allegations are ventilated, and an independent panel will determine if the practitioner's fitness to practice is impaired. Alternatively, and as mentioned before, there's the option for a referral to agreed panel disposal or consensual disposal, where there's no public interest in the matter being referred to a public hearing. And what follows next is that the regulator will draft the agreed panel disposal or consensual panel disposal, and this will then be provided to the practitioner for them to agree, and then it will go before a panel for finalisation and confirmation.
Right, all right. A lot of information there. So ultimately, what sort of action can a regulator take against a registrant? Obviously, you've gone through the various stages. I suppose what are the outcomes and what sort of action can be taken against the individuals?
Sure. So as I mentioned before, an interim order can be imposed at any part of the process, and also the case examiners can impose a warning or informal advice. However, when a matter is referred to a hearing or consensual panel disposal or agreed panel disposal, which is also called, a panel can impose an order of a warning, conditions against practice, a suspension order, and they can also decide to erase or strike off a practitioner from the register, which is obviously the most severe. In some cases, and in regards to the General Medical Council in particular, they can also impose undertakings. However, these require the practitioner's agreement.
Okay, so some really serious outcomes for people. Given the severity of some of those outcomes, how can readouts assist people who are facing this sort of action against by their regulator?
Sure. So readouts can assist with the whole fitness to practice process. This can start off with providing advice in regards to whether to make a declaration to the regulator or not. We can also assist in providing and drafting representations before the case examiners. This could include us drafting the representations or simply reviewing the representations and amending those that have been drafted by the practitioner. And finally, we can assist with hearing preparation and representation. This can stem from interim orders hearings to substantive fitness to practice hearings, and we can also assist with the restoration and registration of panel hearings.
Okay, so the advice would be if anyone finds themselves in this situation to pick up the phone and give us a call.
Oh, definitely. It's best to get advice earlier on, and we can provide you with that advice and any further assistance needed.
Brilliant. Okay, well, that's great. Thank you ever so much, Nicola. I mean, obviously, there's a lot of information there for people to take in. You can find more information on our website, www.ridout-law.com. If you do find yourself subject to any sort of investigation or you get a letter from your regulator, then, as we've just said, please pick up the phone. Nicola will be best place to help and can give you some pointers on that. So yeah, hopefully you won't find yourself in those positions, but you know who to call if you do. So thank you very much, Nicola. It's been really helpful. And thank you to everyone who's watched. Thank you very much.